Welcome back to the deep dive. Today, we are stepping into what I think is probably the most shadowy area of criminal law. We aren't talking about pulling a trigger or breaking a lock. We are talking about the invisible crime. We are talking about conspiracy.
Judge Learned Hand once called conspiracy the darling of the modern prosecutor's nursery. And he definitely meant that as a warning. It is one of the most powerful weapons in the legal system because it allows the government to cast this massive, massive net.
That's the terrifying part, isn't it? It's the crime of agreement. It crosses the line from thought to reality just by people talking to each other. But here is the central legal problem we need to solve today. How does the law even define this invisible crime? Where do we draw the lines on who's involved, how long it lasts, and when it becomes impossible?
Those are the exact questions we're going to answer. We're going to take a really rigorous analytical path through this module to build a framework you can actually use. First, we have to look at the unit of prosecution. If you agree to do 10 illegal things, is that one conspiracy or is it 10? That's the Braverman case.
Right. And then from there, we have to figure out the scope.
Exactly. The dimensions of the agreement.
Hmm?
This is where we get into that kind of geometric logic of chains versus wheels. Use the Bruno and Coteco's cases. Then we move to duration, specifically the problem of concealment and the statute of limitations, which we'll tackle that with Grunewald.
And finally,
We hit the defenses and limits. We'll look at impossibility. Can you conspire to do something that's physically impossible? And a really specific doctrine called Wharton's Rule, which is about the plurality requirement.
Okay, let's unpack this. Let's start with that first concept, the unit of prosecution. So here's the scenario. Imagine a group of people agrees to commit 7 different crimes. Have they committed 7 conspiracies or just one?
The general rule here is actually quite distinct. The gist of the crime of conspiracy is the agreement itself. So a single continuing agreement to commit multiple crimes, that constitutes a single conspiracy. You don't count the objectives, you count the agreements.
Okay, let's test that rule. We need to analyze the case of Braverman v. United States. First, what are the legally dispositive facts of this case?
In Braverman, the defendants were running an illicit liquor business. Manufacturing, transporting, distributing alcohol. It was a classic Prohibition-era operation. They were charged with 7 separate counts of conspiracy. Each count was for violating a different internal revenue law. But, and this is absolutely key, the government conceded that there was only one actual collaboration, one specific agreement among them.
Got it. So just one big plan. So what was the core legal issue the Supreme Court had to decide?
The issue was really precise. Can a single agreement to commit multiple substantive offenses support multiple conspiracy convictions?
And what rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
Absolutely. The court applied what we call the agreement test. The rule is that the conspiracy is the agreement itself. This rule has 2 distinct elements. First, there must be an agreement. Second, that agreement must be to commit an offense. The critical part is that one agreement can't be taken to be several agreements just because it plans to violate several statutes.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the agreement?
So the court analyzed the nature of the agreement by drawing a sharp line between the conspiracy and the actual substantive crimes. The court reasoned that since the single continuing agreement embraces all of its criminal objects, it's fundamentally different from a single act that might violate 2 statutes. The agreement itself is the unit of prosecution. And since the government admitted there was only one collaboration, one understanding, one partnership in crime, well, the element of agreement was satisfied only once. You can't slice one pact into 7 pieces.
Understood. Now, what about the second element, the commission of an offense? How did the multiplicity of offenses factor in?
The court held that the diversity of objectives, all the different tax laws they broke, that doesn't fracture the agreement. The agreement embraces and defines its objects. Whether the goal is to commit one crime or many, it's the agreement that the statute punishes. The multiple offenses are just the details of that single pact. They're like the leaves on the tree, not separate trees.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was reversed. The court held there was only one conspiracy because there was only one agreement. You can't multiply the punishment because the conspirators were ambitious.
Clear enough. One agreement, one conspiracy. Now let's shift gears to the scope of conspiracy. This is what you called the party dimension. How do we connect people who haven't even met each other?
This is a huge issue, especially in modern organized crime. The general rule for what we call chain conspiracies involves successive communication and cooperation. Think of a supply line,
Yeah.
manufacturer to wholesaler to retailer. The element required to link them all into one conspiracy is interdependence or knowledge of the scope.
Okay, let's look at the test case for this. United States v. Bruno. Let's analyze it. First, what are the legally dispositive facts?
Bruno involved a massive narcotics operation. I mean, huge. You had smugglers who imported drugs into New York. You had middlemen who distributed them. And then you had two separate groups of retailers. One group in New York and a completely separate group operating down in Texas and Louisiana. The catch was that the smugglers didn't know the retailers personally, and the New York retailers certainly didn't communicate with the Texas retailers.
And what was the core legal issue?
Was this one single massive chain conspiracy, or was it a bunch of separate ones? Specifically, could you tie the New York retailers to the smugglers and to the Texas group as co-conspirators?
What rule of law did the court apply here? I need the rule regarding community of interest.
Right, the rule is that a single conspiracy exists if there is a community of interest.
Mhm.
This requires that each member knows that the success of their part depends on the success of the whole. It really boils down to two elements: knowledge of the essential features of the plan and interdependence.
Okay, thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply that element of knowledge and interdependence when it came to the smugglers and retailers?
The court looked at the business model. The smugglers knew they couldn't just sit on the drugs. They needed retailers to sell them to make money. The retailers, on the other hand, knew they couldn't sell drugs unless someone imported them. The court found that even without knowing the identities of the people at the other end of the chain, they knew the essential features and broad scope of the whole enterprise. They knew they were part of a larger machine.
Now, what about the relationship between the two retailer groups, the New York group and the Texas group? They didn't depend on each other, did they?
That's the trickier part, for sure. But the court applied the community of interest rule there as well. They reasoned that each retailer knew they were a necessary link in a scheme of distribution. The court analogized them to two salesmen in the same shop. Even if they don't talk, they're part of the same shop or enterprise. The success of the New York group helped keep the smugglers in business, which in turn ensured the Texas group got their supply.
And after analyzing all the elements, what was the court's final conclusion?
The court held it was a single conspiracy. All defendants were part of one large chain.
So that's the chain, but you mentioned a different shape, the wheel. Contrast Bruno with that wheel conspiracy structure.
Right. In a wheel or a circle conspiracy, you have a central hub that deals with a bunch of independent spokes.
Hmm.
The leading case here is Kotakos v. United States.
All right, let's analyze Kotakos then. First, what are the legally dispositive facts?
So you have one man, Brown, he's the hub, and he's fraudulently obtaining loans under the National Housing Act. He did this for many different people, the spokes. He got a loan for person A, a loan for B, a loan for C. But A, B, and C had no connection to each other. They didn't know about each other, and their loans were totally independent transactions.
And what was the core legal issue?
Was this one large conspiracy involving everyone, or was it a series of smaller separate conspiracies between Brown and each individual applicant?
What rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements?
The court applied the rim of the wheel test. For a wheel conspiracy to be a single conspiracy, there has to be a common purpose among the spokes. The rule requires two elements. First, a connection to the hub, which they all had. But second, a shared interest or connection between the spokes themselves, the rim that encloses the wheel.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply that second element, the shared interest among the spokes?
The court found that the rim was just missing. Each loan was an end in itself. If person A got his loan, he didn't care if person B failed. There was no interdependence. Unlike the drug chain in Bruno, where everyone needs the product to move, here, everyone was just doing their own side deal with Brown. The spokes had absolutely no interest in each other's success.
And after analyzing all the elements, what was the court's final conclusion?
The court held these were distinct and disconnected conspiracies. It wasn't one big wheel, it was just a guy with a lot of separate deals.
This brings us to a really critical transition. We've covered the number of conspiracies and the parties involved. Now we need to talk about duration, time. When does a conspiracy end? This matters hugely for the statute of limitations.
It really does. The general rule is that a conspiracy continues until abandonment or success.
But define success. Does the conspiracy continue while the criminals are covering up the crime? I mean, hiding the body or burning the files?
That is the million-dollar question. And generally, success is when the primary objective, the theft, the murder, the fraud, is achieved. Mere concealment after the crime does not automatically extend the conspiracy.
We have to look at the test case for this, Grunwald v. United States. Let's analyze it. First, what are the legally dispositive facts?
In Grunwald, the defendants were in the business of fixing tax cases. They used their influence to get no prosecution rulings for taxpayers. The actual fixing acts happened in 1948 and 1949. But the indictment wasn't brought until 1954. The statute of limitations was 3 years, so the main crime was outside the SOL. But the government argued that the defendants engaged in acts of concealment, hiding records, lying to grand juries, all the way up until 1954, which was inside the SOL.
And what was the core legal issue?
Can a subsidiary agreement to conceal the crime be implied from the circumstances just to extend the conspiracy's duration for statute of limitations purposes?
What rule of law did the court apply, specifically regarding implied versus express concealment?
The Supreme Court applied a very strict rule here. It states that a subsidiary conspiracy to conceal cannot be implied from circumstantial evidence just because conspirators kept secrets. The prosecution has to prove an express original agreement to conceal as part of the primary objective. So the rule has two elements to extend the SOL. One, the main objective must not yet be fully attained, or two, there must be direct evidence of an explicit, express agreement to conceal as a central part of the plan.
Thank you. Now for the court's elemental analysis. Let's walk through that implied agreement argument. Why did the court reject it?
Well, the court reasoned that every conspiracy involves secrecy. It's just part of it. If you allow implied concealment to extend the conspiracy, you would effectively wipe out the statute of limitations entirely. The conspiracy would last as long as the criminals were afraid of getting caught, which could be forever. The court called the distinction between actual and implied concealment a verbal tour de force by the government and just rejected it. So the element of implied concealment fails as a matter of law.
Understood. Now, what about the second element, the express agreement? Could the cover-up have been part of the main objective?
The government did try to argue that. They said the tax fix wasn't complete until the tax statute of limitations ran out years later. And the court actually accepted that this could be a valid theory, theoretically, that concealment was the main goal. But looking at the facts, they found the evidence was insufficient to prove and express original agreement to that effect, and the jury wasn't instructed properly on it.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was reversed. The prosecution was barred by the statute of limitations. The main objective, fixing the taxes, was finished in 1949. The cover-up was not an express part of the original agreement.
That is a crucial distinction for anyone looking at white-collar crime. Now, I want to step away from the tax code and get a little more visceral. We need to talk about impossibility.
This is where conspiracy law gets really aggressive.
Let's say I agree with someone to do something, but it turns out it's physically impossible to do. Am I still guilty of conspiracy?
Yes. The rule is, unlike the law of attempt in some places, factual impossibility is not a defense to conspiracy. Conspiracy focuses on the intent and the agreement, not the likelihood of success.
I have a hypothetical here from the sources, that is. Frankly, it's pretty disturbing, but it illustrates the point perfectly. This is the dead woman rape scenario from United States v. Thomas. What are the facts here?
The facts are grim. 2 men conspired to rape a woman. They approached her, believing she was unconscious from drinking. In reality, she was already dead.
Okay. Legally, you cannot rape a corpse. It is factually impossible to commit the crime of rape against a deceased person. So how does the analysis apply?
The analysis focuses entirely on their minds, not on the victim's actual status. Because they agreed to commit rape, and they had the specific intent to commit rape, they are guilty of conspiracy to rape. The factual impossibility, the fact that she was dead, is completely irrelevant to the charge of conspiracy.
Wow, that definitely sticks in the memory. Now let's flip it. What if what I agree to do isn't actually a crime, but I think it is? This is the deer hunting scenario.
Right. So imagine 2 hunters agree to go shoot a deer. They believe, in their own minds, that it's illegal to shoot deer out of season. But let's say the law actually permits shooting deer at that time.
So they have a guilty mind, but the act itself is legal.
Exactly. And here, the result is different. They are not guilty. This is called true legal impossibility. You cannot conspire to do something that isn't a crime, no matter what you think the law is. The objective itself has to be a criminal offense.
Okay, let me just make sure I'm getting this. If the facts are wrong, like she's dead, you're guilty. But if your understanding of the law is wrong, like it's actually legal, you're innocent.
Precisely. That's the distinction.
Okay. Moving to our final major doctrine, the plurality requirement. Conspiracy takes two, but some crimes require two people just to commit them. Adultery requires two. Dueling requires two. Selling contraband requires a buyer and a seller.
This brings us to Wharton's rule.
State the general rule for us.
Wharton's rule states, an agreement by two persons to commit a particular crime cannot be prosecuted as a conspiracy if the crime is of such a nature as to logically require the participation of two persons for its commission. Basically, the conspiracy merges into the substantive crime.
But there are exceptions to this. We need to analyze the test case. Iannelli v. United States. First, what are the legally dispositive facts?
In Iannelli, the defendants were charged with conspiracy to violate a federal gambling statute. Now, if you look at the statute itself, it made it a crime for 5 or more persons to conduct, finance, manage, supervise, direct, or own a gambling business.
And what was the core legal issue?
Does Wharton's rule bar a conspiracy charge when the substantive offense itself requires a concert of action, in this case 5 or more people? The defendants basically argued, hey, the crime requires a group. You can't charge us with the crime and a conspiracy to be a group.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court clarified that Wharton's rule is only a judicial presumption. It typically applies to crimes where the harm is restricted to the parties, like dueling or adultery. And crucially, the court introduced the third-party exception. This exception has one key element. Does the crime affect society at large? If the conspiracy involves third parties or consequences beyond the immediate conspirators, Wharton's rule does not apply.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply the third-party exception to this specific crime of gambling?
The court looked at the nature of the crime. Adultery involves two people, and the harm is, it's contained between them. But large-scale gambling, that involves bettors third parties who aren't charged with the main crime. It creates a general danger to society, a potential for corruption and violence. The court reasoned that because the consequences extend beyond the immediate conspirators to society at large, the logic of Wharton's rule just collapses. The danger is amplified, so the additional charge is justified.
And after analyzing all the elements, what was the court's final conclusion?
The conspiracy conviction was upheld. Wharton's rule did not apply because the crime involved third parties and general social harm.
We have covered a massive amount of ground. Braverman, Bruno, Kotekos, Grunwald, Iannelli. I want to bring this all together. If I'm a student or a practitioner looking at a complex fact pattern, how do I break this down? Synthesize this for us.
Okay, here is your diagnostic checklist. This is the framework you need to apply to any conspiracy problem. Step 1. The agreement. This is the unit of prosecution. Apply Braverman. Ask yourself, is there one big agreement, or are there distinct, separate agreements? Don't get confused by the number of crimes they plan to commit. Look at the pact itself. Step 2. The scope. Look at the parties. Is it a chain, or is it a wheel? If it looks like a line manufacturer, middleman, retailer, apply Bruno. Look for interdependence. Does the smuggler need the retailer? If yes, it's one conspiracy. If it looks like a hub and spokes one guy dealing with many unconnected people, apply Katiakos. Is there a rim? Do the spokes care about each other? If not, it's multiple conspiracies. Step 3. Duration. Check the statute of limitations. Apply Grunwald. Did the conspiracy end when the crime was done? Remember, you cannot apply an agreement to conceal. Unless there's an express agreement to cover it up, the clock starts ticking when the main objective is reached. Step 4. Defenses. Impossibility. Rejected immediately if it's factual impossibility. If they intended to do it, they are guilty. Withdrawal. Remember, this requires an affirmative notice to all Confederates. You can't just ghost them. And step 5. Plurality. Apply Wharton's rule. Does the crime logically require two people? If yes, look for the Iannelli exception. Does it harm society at large or involve third parties? If it does, you can charge conspiracy.
That is a powerful framework. Before we sign off, I have one final provocative thought for you. The husband and wife rule. At common law, a husband and wife were considered one person. Therefore, they couldn't conspire with each other because, well, you can't conspire with yourself.
That is true. It was a classic legal fiction.
But today,
that fiction is dead. The Supreme Court and most jurisdictions have rejected it completely. The unity of marriage doesn't protect you from conspiracy charges anymore. Spouses face the exact same conspiracy liability as strangers. So, pillow talk can be evidence of an agreement.
a sobering thought to end on. Deep dive complete.
Deep dive complete.